All right, let's get straight into it. If you're staring down a contract law exam, you are in exactly the right place. Today, we're not just going to skim through the law. We are building your exam playbook. Think of this as your high-yield, high-impact guide to absolutely nailing those tricky problem questions. Okay, let's be real. Every law student knows this feeling, right? You've got a case list that's a mile long. But here's the secret. The goal isn't just to memorize all these names. The real skill, the thing that gets you the top marks, is knowing which case to pull out of your pocket and for what point to build a really powerful legal argument. And that's exactly what we're going to map out right now.
First things first. Before you can even start thinking about breach or remedies, you have to answer the most fundamental question of all. Is there even a contract here to begin with? This is always your starting point. It's the foundation of your entire answer. So, let's break down the 4 essential ingredients you need.
It all kicks off with an offer. Now, this isn't some vague chat. It's a clear, definite promise. And the classic case here is, of course, Carlisle. So you've got the Carbolic Smoke Ball Company putting out this ad, promising £100 to anyone who uses their smoke ball and still gets the flu. They even put £1,000 in the bank to show they were serious. Well, Mrs. Carlisle used the ball, got the flu, and she sued. The court said, yep, that ad wasn't just puff, it was a unilateral offer made to the whole world, and she accepted it by performing the conditions. So the exam tip, spot that unilateral offer and crucially know how it's different from a mere invitation to treat, which we'll get to in a sec.
Next up, you need acceptance. This has to be a mirror image of the offer, a total, unconditional yes. If you try to change the terms, that's not acceptance. It's a counteroffer, and it kills the original offer. Dead. And, acceptance has to be communicated. Silence, as a general rule, just won't cut it. But there's that famous exception every examiner loves, the postal rule from Adams v. Linzel. Here, acceptance happens the moment the letter is posted. But be careful, and this is a top-tier point for an exam, the postal rule can be totally excluded if the offer says so.
Now for consideration, the bargain element, the price of the promise. Here's the absolute core exam tip you need. Consideration must be sufficient, but it does not need to be adequate. The case of Chappell v. Nestle illustrates this perfectly. Nestle offered a record for a bit of cash plus 3 chocolate bar wrappers. The question was, were those wrappers good consideration? The House of Lords said yes. Even though they were basically worthless, they were part of what Nestle asked for. A peppercorn would do. Oh, and watch out for a classic pitfall. Past consideration is generally no consideration. The promise has to be made in return for the act.
And finally, the intention to create legal relations. This is the vital filter that separates real legally binding deals from just casual promises between friends. The courts have these handy presumptions. In social or family situations, like in Balfour versus Balfour, the law just assumes you don't intend to sue each other over a domestic promise. But flip that to a commercial setting, like in Edwards versus Skyways, and the presumption is the complete opposite. Of course it's intended to be binding, and you'd have a really tough time arguing it wasn't.
Okay, this brings us to a huge exam pitfall, telling the difference between a real offer and an invitation to treat. Just think about stuff on a supermarket shelf. The case Pharmaceutical Society v. Boots made this super clear. The display of goods, that's just an invitation. You, the customer, you're the one who makes the offer when you take the goods to the cashier. The cashier then accepts your offer by scanning it. Just think, if the display was an offer, you'd be locked into a contract the second you put something in your basket, and you could never put it back. Okay, so we've ticked all the boxes and a valid contract exists. Great. The next logical question an examiner wants you to answer is, what exactly did everyone agree to? It's time to look at the actual contents of the deal. So the terms are the promises that make up the contract. Express terms are the easy ones. They're the things said out loud or written down. But sometimes a contract is silent on a really key point, and that's where implied terms come in. Courts can imply terms in fact using a couple of key tests. The first is for business efficacy, basically to make the contract actually work, like we saw in the Moorcock. The second is the brilliant officious bystander test. Imagine a nosy bystander had popped up while they were making the deal and suggested a term. Would both parties have immediately said, oh, well, of course? If so, it's probably an implied term. This slide is your roadmap for how terms actually get into a contract. First, by signature. The rule from Miss Strange v. Grocob is pretty brutal. If you sign a document, you are bound by it, whether you've read it or not. Second, by reasonable notice, which has to be given before the contract is made. And crucially, the more unusual or harsh the term is, the clearer the notice has to be. Lord Denning famously called this the red hand rule in the Shoe Lane parking case. It's like the term needs a giant red hand pointing at it to be properly included. All right, so we've got a contract, we know what's in it. But what if the whole agreement was based on a lie, or a massive mistake, or some kind of unfair pressure? Now we look at the escape hatches, the vitiating factors that can basically blow up a contract that looked perfectly valid. Now this table, this is revision gold. It lays out the big factors and what they do to the contract. And notice that critical difference in the effect column? A contract based on misrepresentation or duress is voidable, which means the innocent party gets to choose whether to end it or not. For instance, in the Spice Girls case, their conduct was seen as a misrepresentation that they were all staying together. But a contract based on a really fundamental shared mistake is void. It's treated like it never even existed, gone. Knowing that difference is absolutely crucial for your exams.
And now we get to the final, critical stage of our analysis, the part that's often the real heart of a problem question. Someone has messed up. A party has failed to perform. There's been a breach. So what happens now? What are the consequences?
So the main remedy is damages, but you can't just claim for every single loss under the sun. The key limit is remoteness, and it all comes from the famous case of Hadley versus Baxendale. A mill owner's crankshaft broke, and the courier was late delivering the new one, causing the mill to stay shut. The owner sued for all the lost profits, but the court said no, that loss was too remote. They set up a two-part test. Damages are recoverable only if they arise naturally from the breach or if they were something both parties would have reasonably contemplated when they made the contract. Now, this slide shows a really important evolution in the law, and it's something examiners love to see students talk about. For about 100 years, the test for a penalty clause came from Dunlop. Was the fee a genuine pre-estimate of loss, or was it just designed to punish? But in 2015, the Supreme Court cases of Cavendish and Parking Eye totally changed the game. The modern test is much broader. Does the clause protect a legitimate business interest, and is the penalty out of all proportion to that interest? This shows the courts taking a much more flexible, commercially aware approach. So as we wrap this up, if you remember one thing, let it be this. A first-class exam answer is never just a random list of cases. It's a story. It's a logical chain of reasoning that flows perfectly from formation to terms to what went wrong and finally to the remedy. Each case is a tool that you use to build that argument, step by step. That's the playbook. And I'll leave you with this final thought to take into your exam and really into your whole legal career. As you're applying these principles, keep asking yourself, what is the law actually trying to do here? Is it just laying down rigid, inflexible rules, or is it providing a really sophisticated toolkit to try and balance fairness, certainty, and commercial reality? Answering that question is the first step from just being a law student to thinking like a lawyer. Good luck.